Good afternoon, everyone. Thanks for joining us today. Uh, Happy to do this. Actually, it would be fun as an interactive. Wanted to do something, try and get people a little bit more involved in a discussion. Still have enough professionalism and ethics in this to turn this into a continuing education credit. So we've got materials that will be sent out to you. I spend a lot of time when I'm not actually working, dealing with clients or in dealing with other lawyers and mediations, reading and studying techniques for persuasion and dealing with negotiations, everything from difficult situations that may arise to questions about as simple as, is it better to start off making an opening offer or letting the other side make the opening offer? There's an age-old question that doesn't have a definite answer. So for today, we've got some questions that we've gathered from folks before we started today, and we're happy to take any along the way. So please, if you do have a question, anything you want us to try to address, we'll try to do that. With that, Tony, you want to lead us off with?
Sure. Let me throw out the first question here. So, Eric, what is the best way to start a negotiation? And since you had mentioned that first offer, what are some of your thoughts on making a first offer? So, best way
Right.
to start a negotiation, and tell us about first offer.
Start a negotiation. I like to start. You want to take a collaborative approach, obviously. Uh, Sometimes this involves maybe a little bit of small talk, getting parties comfortable. It depends on the setting, how formal it is. Most of the time, although I still have clients that I represent, and I had a discussion this morning with somebody, and we're dealing directly with often an opposing party. If it's parties that either we're negotiating a contract or negotiating a dispute, the direct negotiation is one approach. So we want to start in a friendly, collaborative tone. Try to build a little bit of rapport with our counterpart. And then also it helps to have an agenda, either something specifically that we want to discuss or to frame out an agenda to get a discussion started. If we're in a mediation, a lot of times, if you have a very difficult topic, I'm a very strong believer in using mediation to work through difficult topics. Parties, when they're engaged one-on-one in a negotiation, especially if it involves adverse positions, disputes, often I believe that folks have a hard, well, if science shows that folks have a hard time, cannot really make a point while also listening to the other side. You can't be listening and communicating at the same time. And so if you have a point that you're trying to make, it's very difficult for you to receive a message at the same time. Where in mediation, if I'm serving as a neutral, my job, a lot of the beginning of a mediation involves me listening and gathering information from parties. That enables us to build rapport. As far as once we get into the negotiation, once the issues are framed out, I am a firm believer in priming, and there's a psychological effect of priming. And by priming, we're talking about setting the stage for collaboration, setting the stage for what you want. Something as simple as, if anybody's ever done a mediation with me will know that one of the things I say in the beginning when I make opening comments is I ask people, do you want to try to get your issues resolved? And if you do, are you willing to be open-minded? And I just ask folks to be open-minded. And believe it or not, there's a lot of science behind that statement that suggests that asking people to be open-minded tends to lead them to being open-minded. And there's studies, I don't want to veer off too far, but I'll tell you that there's some studies. There's a book, interesting book called Methods of Persuasion, written by an author, Nick Kalenda. And he cites this study in his book on when he's talking about priming, where it's been shown that if you say something as simple as, hey, I listened to some new music, new Christmas music this year, holiday music, and it was something I thought I really wouldn't like, but I gave it a second chance, and I'm glad that I did because I actually enjoyed it. That type of statement showing open-mindedness leads others in the discussion to be more open-minded. So I use direct statements and ask people to be open-minded in a mediation because of the priming effect. Robert Cialdini, in his book Influence, which is a fantastic book, it's actually one of the few books I have in hard copy. I listen to it and read. He talks about priming as well. He cites another study. This is a really interesting one. I like this study a lot. Uh, they did a study where they had somebody who was supposed to be a surveyor on, I believe it was on a college campus environment. And that surveyor would stopping people and asking them questions as part of this survey, this research study, and then sending them to another spot on the campus. Well, some of those folks, they ask questions about career. Why did you choose the career that what do you do? Why did you choose that career, et cetera. And then another group of folks, they asked them about the first time they fell in love. And they didn't realize that the questions about their career or why they fell in love weren't the research study. The study was how friendly and cooperative were those folks after they had that first engagement when they were on their way to the second office where they were supposed to pick up some paperwork and get paid for participating in the study. On their way to the second, after being asked the questions, on their way to the second appointment or the second stop, they were asked by a stranger who was actually a participant, a collaborative person in this study, stopped and asked them for directions to somewhere else. And they found that by a very large margin, the folks who were asked about the first time they fell in love were much more cooperative. So if you want to get people in a frame of mind of being cooperative, if, for instance, this time of year, if you're asking for contributions for charitable endeavors and so forth, mentioning love, something as simple as uh, share the love this season by supporting whatever. Mentioning that type of using those type of words can actually have an influential effect on folks. Second issue beyond the priming effect is framing and anchoring. So there's a something that's going around on social media. It talks about how to negotiate. It says never make the first offer. I read this recently. Never make the first offer in a negotiation. Well, it's really a case by case issue. And you asked this directly, Tony. What do you think about making first offers? If you have a good amount of information and you want to try and frame a negotiation, then the anchoring effect is very strong. This has been shown in even court scenarios with lawyers and judges who are educated on a particular topic, such as sentencing, that folks will gravitate towards an anchor. People tend to exaggerate and use it too often. We do mediations where somebody makes a demand for $1 million, the other side's willing to pay $100, and you have to bring the parties together. But if this has been shown in studies where folks are selling in a hypothetical situation involving people selling a business, that if you have somebody and they think their business is worth around $5 million, I think is the study, and somebody comes in and offers them 3, and then they have a second person that comes in and offers them something less, they will lower their expectation for what they think the value is of the business, even though they have the most information about their own business. Anchoring is a real effect, and often I believe if I'm representing a party in negotiations, I often want to try to frame the negotiations with an anchor or something around, especially if it's dollars, numbers that are more friendly to my client. So anchoring, backed by research, and framing the negotiation and priming are 3 big issues that help set the negotiation off in the right direction. Other questions? I'm going to go through one. Let's see one on here. I'm going to take another one off of our
I have
list.
another one here.
Oh, good.
So what's the best way to counter a take it or leave it offer?
Best way to counter a take it or leave it offer. Uh, Well, what we want to do with something like a take it or leave it offer is we want to have already hopefully built some degree of rapport. And I suggest rather than to try to reframe the response, um, something as simple as using a no-oriented question to allow some psychological comfort on the other side. Something like, would it be crazy of me to ask if there were other alternatives? Or would it be a ridiculous idea for us to spend a few minutes while we're here already exploring alternatives to that offer, something else that might work for both of us? Trying to reorient your counterpart, reframe the question, uh, and then try to introduce in that some again, they could be alternatives with conditions. You can say, okay, let's figure out, would it be crazy for us to consider, or would you object to considering some other alternatives that you're welcome to say no to, but let's list five at least, so I've gone through the exercise. Make it something like you've got to check the box depending on the context. What you want to do is get away from a yes or no and get into a framework where you are allowing the other side to essentially say no to your response and respond to that with other suggestions. And use time also as as a friend in negotiations. I'm a firm believer that uh, a lot of things don't happen fast in a negotiation, but if you allow time to take its effect, it's very much, in my view, I like to consider time as the analogy of time and taffy. If you take a piece of taffy and you try to do something with the taffy, bite into it or break it or bend it, it just snaps into pieces when you first have it in your hands. But if you hold it for a little bit, let it warm up, and slowly try to manipulate the taffy, it eventually softens up to something that you can work with. And folks in a negotiation, I believe, are very similar. When they first sit down at the table, they're not ready to move. We have to build a little bit of time, build a little bit of comfort, build some rapport, show a little bit of empathy for the folks that we're dealing with, and get them into a framework of having a discussion rather than just tossing things out that we can say yes or no to. Good question.
Okay, let me go to another one here. Let's see. I guess, well, you started off about how to start a negotiation. How do you know when it's time to stop negotiating?
Good question. How do we know when it's time to stop and negotiate? Well, one, if we have a deal, right? So once we have a deal, don't continue to negotiate. Don't negotiate against yourself. Sounds obvious, but I've seen people do that. You see people do this when they're nervous and they're shopping for a high ticket item like a car, um, where you reach a deal and then you continue to add pieces to it. I've seen people do this in mediations where we reach a deal and they continue to talk about concessions that they can make. Uh, Once you have a deal, the key in my view is to stop talking. Beyond that, we there's an ethical component to this, so we want to be careful under the Florida mediation rules, especially if I'm in the role of a mediator. We don't want to uh, shift from trying to let parties self-direct themselves into a settlement to where we're using undue influence over parties. So that's something we have to be very careful of. We don't want to force anyone, mediations especially are voluntary processes. Negotiations should be voluntary processes. If somebody gets forced into a bad deal, if you get somebody to commit to something in a negotiation, one, if it's not signed, there's likelihood that maybe you don't get a deal signed. If it is signed, there's probably a better likelihood that if they've signed something they believe is a bad deal or an unfair deal or there was undue influence, that they won't honor the deal. Um, and then otherwise, as I said with the response to the last question, I'm a very firm believer in the benefits of time and allowing parties to reach solutions, even allowing counterparts in a negotiation. If I'm representing a party in a negotiation, allowing counterparts, lawyers, or whoever I'm dealing with on the other side, or parties on the other side, to to take their time to come to a point of agreement. Uh, and then sometimes it's just not going to happen. So no deal is, a lot of folks have said this, and I'm not the first to say it. No deal is better than a bad deal, usually. Uh, we don't want to have somebody forced into something that they're not comfortable with. And sometimes you just know that somebody's not there in good faith. If you get the sense, and I had this happen to me not too long ago, where I was in a mediation with some folks, And very early in the process, I got the sense that one of the parties was not there to do a deal. And they weren't going to be open-minded. They were very difficult to deal with. And I usually like to find that out pretty early, so we're not wasting people's time as well. I'm willing to sit with folks all day. I'll sit oftentimes as long as it takes to try and get a deal done. If time is going to be helpful in that regard, but I also don't want to waste anyone's time. And if you have one party who's not acting in good faith, uh, that can really, it can make a whole deal. And what ended up happening in that particular circumstance was we went for several hours. We negotiated a deal. After about 4 hours in a mediation, we were drafting the settlement agreement, and there were some terms that they wanted, that same party tried to include in the settlement agreement. It just blew up the settlement. It wasn't going to happen, and they were completely inflexible in negotiating the terms, and the deal fell apart. And that's one where I actually looked at it and thought, I saw that coming within the first hour. I wanted to let the process play out, but it was a shame because we wasted time. So if you get the sense that somebody's not acting in good faith, uh, maybe give it a little bit of time, but that's going to be a big signal to you if you don't think they're there to be. And if people are not honest, there's another one as well. If folks aren't acting in good faith, if they're not honest, they're hiding information, they're not giving you accurate information, especially stuff that you can verify, and folks aren't telling you the truth, then that's a good sign that your negotiation is not going to go anywhere and it's time to stop.
So you actually jumped into one of the other questions. I was going to say, let's get into the ethical and professionalism questions. So one of them here was, how should a mediator handle a situation where one party is not acting in good faith or intentionally misrepresenting facts during the mediation process? So I think you answered that pretty well. Let's jump into one of the professional questions here. So if a lawyer has dual roles as an advocate and an informal mediator, how can they avoid crossing ethical lines in negotiations?
Oh, good question. I have this come up on occasion. I'm not, I'm doing more mediations and I'm not litigating, or my litigation role is diminished, but I have a couple clients. I don't want to leave them abandoned, and I want to make sure we get things closed out for them. So I see this in my own practice where I have to be very clear about what my role is, whether I'm a lawyer or I'm a neutral. One is we want to clarify the role in writing. With clients, I have written engagement agreements with every mediation I do. I have a written engagement with the attorneys, and I send that out. I don't have it signed, but I do send it out and ask that if anybody has any objection, that they let me know. Uh, Want to be cognizant of identifying any potential conflicts. So when somebody's scheduling or when we're inquiring about a mediation, I I find out from them the lawyers and the parties that are involved and we run it through our conflict search in the law firm to make sure there's no conflict. Uh, then when I start off a discussion in a mediation, when I start off that in my opening comments, there's a few things that we're required to discuss with parties to a mediation and the attorneys, the fact that the process is voluntary, it's confidential. And I discuss my role, that although I am a practicing attorney, I'm licensed in Nevada and in Florida. I don't serve in that role as the mediator. I don't have um, any basis or right to make anybody do anything. I'm not there to give legal advice. Each of the parties, typically I'm dealing with parties that have attorneys present at a mediation, so I tell them to rely on their own attorney for legal advice. But I also let folks know that in my experience, having litigated a lot of different business issues over the past over 20 years, um, I may give them some feedback just based on personal experience, but it's not tended to be legal advice. Uh, and then another balance that I have found, and I'd be curious if other folks in a similar role have had this come up, is most most of the times if we get a settlement done at mediation, and oh, here's another priming. I'll tell folks in beginning of mediation, in most cases settle in mediation somewhere around probably over 80%. And in my own experience, that's been the case. Over 80% of cases settle in either in the mediation, by the end of the mediation, or shortly after. That's another priming effect, that it's a Robert Cialdini influence principle that people tend to social proof. People tend to follow what other people do. So if you tell people ahead of time, look, most mediations settle over, 4 out of 5 or better than 4 out of 5 settle. It's another priming effect. So in my discussions with folks, I'll have the opening, we'll have the mediation, we'll close everything out, and sometimes there's follow-up with respect to a settlement agreement, either getting parties to sign it if for some reason there's an additional party. I recently did one where somebody who wasn't at the mediation had to agree to a specific term. That makes things difficult. Best if we can get everybody there, but under the circumstances here, we weren't able to do that. Sometimes there's conditional approvals. Again, not ideal. We want everybody with authority to show up at any type of negotiation or mediation. And sometimes there's issues with after the parties sign in the follow through. Some more complex cases, and I deal with quite a few of those, have multiple moving parts. It's not just okay, we settled at mediation and party A is going to pay party B this amount of money in this amount of time. Sometimes there's property transfers, stock transfers, business transfers, closeouts, notifications that have to be done, real estate transfers. It's sometimes there's other moving parts. Parties agree who's going to be responsible for tax consequences, for other issues down the road, and seeing the settlement agreement carried out, you have to be very careful. And there's some Florida MEAC opinions on this about not overstepping as the neutral and becoming an advocate and taking the position, okay, you have a settlement agreement that says this, that requires one party to do something else when you recognize that those parties are in dispute over that issue. So in my view, the best course of action, once you have a signed settlement agreement, if one of the parties approaches me, and I've had this happen, where somebody comes to me after and says, hey, we have the settlement agreement, it says this, I'm trying to get the other side to do this and they won't do it, can you help? I see my role in helping as, again, making sure that I'm neutral. Look, I can't advocate for anybody. You do have a settlement agreement, but how can I help facilitate the communication to make sure we do everything that the parties believe they agreed to do and what the settlement says. So that sometimes creates a fine line. But it's always, it really comes down to communication, making sure that we're very clear about what our role is, either as the attorney or as the mediator.
Excellent. All right. So we have a question from the audience here, from Amara Smith. In my experience, I had a great mediation where the mediator sensed where each party was with their negotiations. And she said, if you offer X amount, I'm pretty sure that would give us a resolution. Offer was way less than what W was asking for, but higher than what H asked for. As a mediator, how do you know when to step in and suggest numbers or terms?
That's a great question. I hate to give this answer that how do you know when to suggest numbers or terms? Some of it's from experience, some of it's gut. It comes back to spending a lot of time in the early part of the mediation. After I get done making opening comments, I tell parties ahead of time too, like, look, you may not see me for a while if I'm in a separate room with somebody, because I want to listen and gather as much information as I can. In listening and gathering information, coupling that with experience, you sometimes get an idea where people are. But I've been wrong. There's times I think, okay, this is, especially when we're talking about dollars and numbers, I think, okay, I think this is where this case will settle, and I'm totally off. That happened to me recently. I was way off, and I didn't see it. But you usually get a feel if you're listening and you see where people are. Some folks are more trusting and more reliant on the mediator, and I'm fine with that. You have two general rules, and folks should know this if you are an attorney representing folks in mediation, or if you're ever going into one. The general rule, everything in a mediation is confidential. So I'm going to kind of back up and go into the basics a little bit. The general rule is everything in mediation is confidential. And then you have your mediation joint session. Can't talk about anything outside of the mediation. Then you have your separate breakout sessions. And those sessions can be confidential so that you don't share any information you learned in that breakout session with the other party, or you can share information if the party allows you, if they give you permission. So I typically say in the beginning of a mediation, look, once we go into breakout sessions, I'm going to assume if you tell me something, I can share it. And there's a MEAC opinion that allows us to do this. I'm going to tell you that something, if you share information with me, I'm going to presume that I can share that information unless you tell me otherwise. If you want me to keep that confidential, let me know, and I'll keep it confidential and not share everything. I've had people in the very beginning, and I'll respect and honor this. We go into the breakout room, they say, Eric, we don't want you don't share anything unless we specifically give you permission to share it. That's fine too. It sometimes makes it difficult, but we can certainly respect that, and we can certainly get, work under those conditions. Um, so some folks will tell me, like, look, this is where I want to land. I've had clients or the attorneys just come out and say, look, this is where we think this lands. We're going to rely on you to help us try and get there. I'm not the advocate, but I can read the other room. Sometimes there's multiple parties involved, and see where I think people are going. And then after I've built some trust and have a rapport and uh, and have gathered a good amount of information and understand things pretty well, I will sometimes just come out and ask folks, and I'll ask without committing one side. Say, look, I don't know what the other side's going to say, but if I could get you to this number, is that something that you would be comfortable with? And then I can go back and ask the other side, look, if I could get you to this number, I don't know if it's going to work or not. Is that something you would be comfortable with? And where that will sometimes lead is to a place where I know one side's number. They don't want to make One side doesn't want to make an offer because they're afraid whatever offer they give, they're going to get a counter offer that's less, right? So it's the idea, like my wife always tells me, if I put something for sale on Craigslist, ask more than what you want, because somebody's always going to come back and try and get a deal. They feel better if you list it for $500 and they pay four than if you list it for 350 and they only pay 350. Like, people feel better getting a deal, and I think there's a lot to that. So folks in a mediation may be afraid, if I make this number, this offer, the other side's going to counter no matter what. So the way we frame it is we just turn it around and say, if they agree to this number, or if they made this offer, would you accept it? Or another way to do it is, I know one side has a specific number in mind. The other side, I say, they haven't offered this number, but I have a good feeling that this is where they are, and they would you be willing to make this offer to them so that that other side will accept the offer? So there's ways that the mediator can frame these questions to protect the parties, so that you're not putting an offer out there. All of a sudden, you put a number out, they've countered. Now you're like, okay, how do I get back to the number without it looking like I'm not acting in good faith because I'm not negotiating? So my recommendation would be to whoever you're working with in mediation, ask them, here's where we want to get. Keep this confidential. Please don't share it with the other side. You're entitled to that protection. This is where we want to get. How can we get there? Do you think it's realistic? And how can you help us get there? And allow the mediator to use their skill set and the information they have to try to get you there. And one other thing I'll add on that, and we can, if there's another question here, we can certainly take that. But there's the idea of a mediator number. And anybody's ever heard this term, there's different tactics you can use in mediation, but this is sort of a last ditch attempt where you see a number that makes sense. It's usually it's going to be a case that involves a dispute over money, where one side is trying to get paid from the other. You see where it makes sense for parties to settle a case, but they just can't get there themselves. One tactic that you can use is to present a single number to both sides, and it works well with a two-party mediation in particular. So you say, look, I'm gonna propose a number. I'm gonna come up with it on my own, so the parties don't have to do it. But based on everything I've heard today, I'm gonna put a number out there. And if party A agrees to it and party B agrees to it, we've got a deal. But if either party disagrees, they don't know what the other party said. And then that is another way to protect you. So put yourself in the shoes of the negotiator there. If I agree to the deal and the other side doesn't, my worry is, well, now they know what my number is. They know I'll take that number. Well, they won't know that because the mediator doesn't tell them. I don't tell them. And if you accept, if you say, I'll agree to the number, but the other side, the mediator comes back and says, we don't have a deal. The other side did not agree to it, but the other side doesn't know whether you did or not, because if both sides say no deal, then there's still no deal. On the flip side, if I say, no, I'm not going to accept that number, and the mediator comes back and says, we don't have a deal, I don't know whether the other side said yes or no. Because when I said, I'm not accepting that number, that was the moment that we knew that we didn't have a deal. So that's another tactic that can be used in a mediation, again, to protect people where it's a little bit beneficial rather than just doing a one-on-one negotiation where you have to put that number out there and you're not sure what the other side's going to say.
Excellent. Let's get into another one of the transparency questions here. How should attorneys handle situations where their clients' goals conflict with legal or ethical norms?
Ooh, um, how should attorneys handle situations where the goals of the client conflict with ethical norms? Uh, you
Or,
have
or,
to
or legal?
ethical or legal norms. Uh, well, the attorney has a duty to educate their client, obviously, and that's beyond the role of the mediator. If I'm the mediator, I want to uh, remind folks to act in good faith. There are some exceptions to confidentiality, by the way. I never see them come up in my mediations. Generally, I'm usually dealing with fairly sophisticated folks that are represented by attorneys. But if anybody threatens to harm someone or some illegal conduct, there's some very limited exceptions to the mediation confidentiality rules. You can point that out. If you're the attorney and you're working with a client who is not being honest or is suggesting something illegal or something even unethical that you have a problem with, I think you have a duty to communicate with your client. And you may be in a situation where you say, one, if you choose to proceed with that strategy, you could end up in trouble. Here's the legal consequences you could deal with. Um, and if it's too much, then you may be in a situation where you need to consider withdrawing. Um, how to handle it as a practical matter, you want to offer alternative solutions whenever possible. So try to figure out what the client's objective is, which you should have a good understanding with. Look at the broader objective of the client and try to consider um, something as an alternative to what the client's proposing. For instance, you might say instead of trying to get this provision in an agreement, we can achieve the same goal uh, without violating this law or something. I see a lot of compliance issues in my practice because I represent a lot of professionals, especially healthcare folks. Um, Try to suggest an alternative that works. Uh, you also, as the attorney, you want to, and most of the folks here are attorneys, you want to document what you've discussed with the client. Honor confidentiality, respect confidentiality, obviously. But if the client is asking you to do something you're not comfortable with, I suggest something like an email back to the client saying, look, this is what we discussed. And here's the alternatives that I've proposed. We can't take that course of action because of these potential consequences, or I don't think that's a good idea. In my judgment, maybe it's not illegal, but you say, look, I don't think this is a good course of conduct because these are the repercussions you could have to deal with. If you have a good relationship with your client, they should be listening to you. And if your client's not listening and respecting that, that's going to be a difficult client to deal with anyway. So probably you want to be looking at some alternatives to a long-term relationship with that client. Uh, and then and finally, the attorneys, of course, have to be cognizant of their own ethical rules. And for those who don't know, if anybody ever has a doubt, for the attorneys, I think most attorneys know there's a hotline you can call, and I've used that hotline myself to call the Florida bar and run ethics questions by them. They keep it confidential, and they can give you some good guidance as well.
Excellent. All right, let's switch it up with a little technology use here. So, Eric, we noticed that you do a lot of mediations via Zoom these days. So, what steps should mediators take to ensure confidentiality and security in virtual mediation platforms, whether it's Zoom or Teams or whatever you're using these days?
Well, very good question. We do a lot by Zoom. I actually I continue to be very happily surprised by how effective virtual mediations are. For several parties, it might be a little bit more difficult, but especially 2, 3 party mediations. And I've had as many as I think 9. I've done some hybrids where there's been people in person and by Zoom, where there were several different attorneys, but usually there's one primary, and maybe there's insurance, or there's co-counsel or somebody else who's involved. Uh, Obviously, you want to choose a secure platform. Uh, Zoom works. You can control, we can password control, we can control who's coming in. Interesting anecdotal story here. A while back, I had a mediation we were doing by Zoom, and it was two-party mediation. It was a pretty simple, straightforward case. There's nothing exciting about the case itself. But as we started the mediation, I can see, and if you use Zoom, there's a way to see who's trying to come into the Zoom. You can see the participants, and what I do is I let the attorneys in. I try to understand who's going to participate from the very beginning, and then if there's somebody that I'm not sure who they are, I'll ask the attorneys while we're on, do you know who this person is? Who else is coming into the platform? Um, well, I had this one particular case where people kept trying to get in. I said, "Well, do you know who this is?" No, nobody knows who it was. Then it happened again. Do you know who this is? No, no. I had maybe three, four, five people at a time. It looked like anybody's ever done like a calendar call hearing with a court where there's a whole bunch of people that are all waiting to come in or all trying to get in. It looked like that. And so then the folks told me, one of the attorney told me that that client that he was representing was apparently a quasi-famous social media influencer, or online personality. And so a bunch of people must have been following the court case, and they put the Zoom credentials in the hearing notice, or pardon me, in the mediation notice. And so folks were trying to get into the Zoom to monitor it for the mediation. So I might suggest that I don't know if there's any requirement to put the Zoom or virtual, whatever platform you're using. I like Zoom because it's very easy to use, it's secure. I might suggest not, for the attorneys, not putting that in the mediation notice. But I'm not aware of any restriction that says you can't, and I'm aware of the requirement that says that you can. Um, Whenever you're in a Zoom, it's a good idea to ask folks, I'll ask if there's anybody else that's in the room with the person, remind the parties, especially of the confidentiality of the mediation process, and let them know that ask them, is there anybody else in the room with you? Can anybody else hear you? Or are you in a setting that's confidential? If anybody comes in, would you please let us know so that everybody knows that there's another participant there? Uh,
And you're also utilizing breakout rooms and things like
and we're
that
using the
Zoom
break, that's
offers.
right. And we're using breakout rooms. So there's a lot of steps that we can take, but the Zoom with the breakout rooms and making sure that we only have people that are supposed to participate is pretty good for that.
Let's go on to another technology question I have here. I thought this one was pretty interesting. So what are the ethical implications of using AI or data analytics tools in the negotiation process? So we see a lot of new AI tools coming out. I'm sure a lot of the folks on here have seen ChatGPT. Maybe what are the ethical implications of maybe using that to try to help work your argument, or some other type of data tool? I think it's more of a personal opinion.
Yeah, I mean, we don't have a lot of rules and opinions on this so far. I mean, we've got the horror stories from folks using improperly using ChatGPT and other AI tools. I think it's a great tool, by the way, for certain uh, components. I think it's a great tool for new ideas. I think it's a great tool for gathering gathering and organizing notes. In fact, for this session today that we're doing, and for some other stuff that I've done in some other mediation and negotiation seminars, I've run some of my own notes just when I'm reading Cialdini or reading Chris Voss's book or listening to something, a podcast, and I hear something interesting. I drop it into OneNote, and I'll take my OneNote every once in a while, which is all public information stuff I've just pulled out of different sources, and I just scratch it down and keep track of it. And I'll take my OneNote and drop it into ChatGPT, and it does a great job of organizing it. I think maybe I just gave away a secret, but it does a fantastic job of just organizing my notes, and then I can go back and ask questions and based on the material that I've fed into ChatGPT. Of course, if you're dealing with legal cases, you don't want, there's some discussion of required disclosures if you use artificial intelligence to draft a motion. You don't want to rely on artificial intelligence to draft a motion. It's something different if you're talking about public information that you're organizing. And if you are going to ChatGPT to get answers, you have to verify that stuff, because I know that it will give you it'll completely make up cases. Obviously, that's for that case in New York where the folks got in trouble. It'll make up rules. It'll make up statutes. It'll totally make stuff up. So I look at it like relying on maybe a young attorney or an assistant to go do some legal research. You can maybe use it as a starting point to look at some things, but you need to go verify and actually read the material yourself.
Maybe
Um,
organizing your thoughts and just watch out for the hallucinations from the
yeah,
AI.
hallucinations, AI hallucinations. That's the first I've heard that. That's yes, exactly. Confidentiality is an issue to mention as well, because no one knows what's happening to information that you put into Chat GPT. So if you're dropping confidential client information or settlement discussions or something else into Chat GPT, I know that there's some supposedly secure platforms. I know that Thomson Reuters, West, Lex, probably every legal research platform now is now including an AI component. And Tony, you're the technical guy; you would know this more than me. But what it looks to me to be is just a wraparound. So we're taking Chat GPT and putting it in a closed environment like a Westlaw research database, and we're using that to generate answers. So at least the stuff's more reliable with some links to it. But because it's in a database like that, I'm not aware. I don't know what happens to that information. So I think you have to be very careful in the information that you put in your inputs in the Chat GPT, and make sure you're not inputting confidential information. Use very generic information.
Absolutely, I agree with that. Let's move over into some of the questions under handling challenges and dilemmas. So, how about this one? How should a mediator respond if one party accuses them of bias or favoritism during the process?
As the mediator, you always want to be calm. You want to maintain neutral expression and composure, like calm composure, neutrality. Um, don't get defensive. Uh, I usually try to. I haven't dealt with that directly, but when if somebody gets upset, I try to take the opposite approach. And where I get a lot of practice for this, by the way, is at home with my kids in particular, trying to not respond too quickly, respond with an inquisitive mindset and not a defensive mindset. And I meditate on that several times a week, again, because I'm dealing with my kids. Uh, so I try to be curious and inquisitive. I'm sorry you feel that way. Let's talk about that and make sure that we're on the same page and you're comfortable moving forward, and try to find out what's at the root cause of that accusation. Of course, we want to emphasize fairness and impartiality. Now, I'm in a little bit different situation. I recognize that in the mediations that I'm involved in, because it's generally at least one of the parties has invited me to the dance, so to speak. I imagine it may be tougher if you're in a county court situation where you're doing mediations with folks who are walking in and you're meeting them all for the first time and you don't have a prior relationship with them. I usually do have a prior relationship with some of the attorneys that I'm involved in, sometimes attorneys on both sides. That hasn't been a concern as far as I can tell with the other counsel involved. And I like to think that that's based on reputation, that I have a good enough reputation that I don't have to deal with that directly. But if you're facing that type of situation, uh, try to get without being defensive, try to get to the root of the accusation and try to rebalance, and try to uh let the parties know, like, hey, let's try to ensure that all the parties have equal opportunity to share their perspective, to provide ideas, and remind everybody that the process is voluntary. Nobody's being strong armed in doing something they don't want to do. There's no obligation to do anything in mediation. You certainly have no obligation to reach a settlement. Uh, and there's no deal in mediation. One of the Florida strict rules, you can have several, misconception here on settlements and agreements. You can have verbal agreements and you can have verbal settlement agreements. And I've seen those enforced. In fact, I was involved in a heavily um, contested settlement involving a series of email communications But for mediation, the rule is hard and fast. Mediation is only enforceable if it's signed by the parties. And if you're not comfortable with something, I would say, you have remind parties as the mediator, you don't have to sign anything. And if they're not comfortable signing it, then what's going to make them more comfortable? Is it going to be time? Is it going to be consulting with counsel if they haven't had the opportunity to do that? Consulting with another advisor, again, with reminding them that there's a confidentiality to the mediation, but sometimes people may want to talk to a tax advisor, talk to legal counsel, talk to a spouse, and you want to get permission with the parties to the limits of what they can do in that situation. But you want to, it's inquisitiveness um, and not being defensive and trying to get comfort and communicate with the parties. And if that doesn't work, then again, it's a confidential process, and maybe that's not the day to get the case done.
Excellent. Let's go into conflicts of interest here. So, which steps should a negotiator take to maintain professional boundaries when negotiating with friends, colleagues, or former clients?
Similar to the question was asked earlier about understanding your role in the process, understanding your role as a uh, mediator, as an attorney, as a negotiator. You want to make sure that the expectations are set clear and early in the relationship. Um, I tell folks at the very beginning, I am a practicing lawyer. I have a law firm. I have an active law practice. I've been doing it for a long time. I know a lot of people, um, and I actively manage my practice. But my role today is not as an attorney. I can't give legal advice. I am here as a neutral facilitator. If I am negotiating with somebody where I think there may be a misconception, I might say, like, look, I value our relationship, but during this negotiation, I am going to treat the process as I would any professional engagement to ensure that I'm being fair to everyone involved, including whoever my client or the party that I'm representing is. If I'm serving in a as a professional role as an attorney. Um, Try to keep personal matters out of it and stick to issues. And I also like to I personally like to uh, frame disputes as issues. This goes back to sort of the getting the yes, Urey and Fisher principles of negotiation, that you attack issues and not people. And you attack, maybe not attack, but you evaluate positions and not opinions. Um, and by keeping your focus on a more objective standard of issues and how the parties, how we can resolve certain issues, you can maintain that personal relationship after it's all said and done, and still, you can be adverse, and you can be, what's the term? You can disagree without being disagreeable.
Excellent. All right. Let me get one more in here. I think we can squeeze in here. Let's go back into the challenges and dilemmas. How should negotiators deal with hardball tactics that push the boundaries of ethical behavior without escalating conflict?
Hardball, I did a whole webinar and seminar on hardball tactics. Um, what I like is to rely on objective standards. So a lot of hardball tactics involve, you got the take it or leave it offer, good cop, bad cop, um, bluffing, and where do you draw the line between bluffing and misrepresentation, bluffing, puffery, and flat out lies. Uh, I prefer to, again, focus on issues and not people, focus on resolving conflict and not attacking positions, uh, and use an objective standard. That to me is always, and it's building trust, building rapport in the beginning of the process. Use what Chris Voss in his book calls calibrated questions. Uh, and there's another negotiator that it refers to these as interrogatory questions. I've seen different terminology, but the way you frame responses to things, I think is very effective. And again, if you want to test this out, if you have kids or somebody you have maybe a debate or an argument with, try this approach. Especially if you have a good rapport with them, there's some things you can do to build rapport as well with mirroring and labeling. But as far as dealing with a hardball type approach, avoid why questions and use what and how. And for attorneys, if you're drafting interrogatories, uh, this should be pretty easy to do once you get the hang of it. Why do you think? Why would I do that? Why are you demanding that? Why would I do that? Why would I agree to that? You can turn that around and say, what about that offer is fair? Or what makes you ask me to do that? Or how am I supposed to do that? Or how do you think I can accomplish that and still maintain integrity? How can we get a deal done where I don't feel like I'm being totally taken advantage of? And what's a way that we can move forward collaboratively that's going to work for both sides? And simply using different wording, it sounds almost too easy. But I promise you, if you try this out the next time, if you start sensing yourself getting into a little bit of a more heated debate, this happens sometimes in my house where a conversation starts to escalate a little bit. And I love doing it with my kids. When my daughter asks me for something, I have an 11-year-old girl, and she asks me for something I don't want to agree. Instead of saying no or asking her why she's asking me that, I'll use what and how, and I'll continue to just keep asking her questions. Sometimes she just gets frustrated with me and walks off. But I recently got her to agree to something, and I looked at my wife and I said, I never once said no. I never told her no, and she just sort of gave up on the idea and walked away. So, well, what makes that a good idea? Let's evaluate that. What makes you ask that, and how can we get something done that makes sense? So try that type of questioning. And when you're dealing with a hardball type person or somebody who appears to be a difficult person, try to avoid the why, use how and what, and just ask questions about what they're asking you to do.
Excellent. Eric, I don't have any other questions from the audience. I'm going to give you one of mine to wrap it up. And this is about the post-mediation and follow-up. So how involved should mediators be after an agreement is reached, particularly if disputes arise over the settlement terms?
We touched on that a little bit earlier. And I had this issue come up recently. We always have to, I want to be clear about my role as a mediator in the beginning of a process. And sometimes I need to come back and revisit that. So a few things that I'll do, and I'm going to tie these all together, back to the priming. I ask people in the beginning of mediation, let them know who I am, what my role is, remind them I'm an attorney, I'm licensed in a couple of states, but I'm not serving as an attorney today. I'm a neutral facilitator. I'm here to mediate. I can't give legal advice. I can't give you opinions. I can't give you any rulings and make you do anything. That said, I'll work with the parties, try and gather information, help guide them in a direction towards settlement, show them all the alternatives. Use a lot of prospect theory, loss aversion to steer people away from all the bad things that can happen in negotiation or in litigation rather. And I'll ask them, I say, do you want to settle? I ask people in the very beginning, I'm going to ask you a question. Do you want to try and get your case settled? And if you want to try and get your case settled, are you willing to be open-minded? That's it. Do you want to try and settle? Are you willing to be open-minded? And then back in the process, when I'm in sessions with folks, when it gets difficult, I'll come back to that. I asked in the beginning, do you want to try and settle the case? And it's a rhetorical question at the very beginning, but later in the process, it becomes a not a rhetorical question. I try to steer for an answer. Do you want to try to settle the case? Because if not, if you're just there going to be trying to be difficult, then let's not waste time. If you want to try and settle it, then let's work together. So I've primed them for that. I want them to be open-minded. I'm constantly communicating with them. And then after it's all said and done, if we are in a situation where you asked, what's our role afterwards, after an agreement's reached, if there's a dispute over settlement terms? I've had that recently, and I have to come back and remind the attorneys in one case where, look, I'm I want you guys, we work towards a settlement. I remind them of all the work that went in. There was one in particular, 26 hours over a couple days, 26 hours that went into getting a deal done with multiple parties. We've got a deal done. There's the final pieces we just need to work together to follow through on getting the deal done, but I can't advocate. I can't pick up the flag for somebody and run across the finish line. I'm happy to jump on a mutual call with everybody. I'm happy to try and facilitate communications, send emails like, hey folks, what's going on with this? Are we talking? Do we need to jump on a joint session? Let's do that. But I can't be the advocate. And I always remind people, look, I can't, if you guys are fighting over this, there's nothing I can do about it. I want to keep you out of the fight, but I can't take anyone's position in the fight. Um, since I have like 2 minutes here, um, folks have heard of the concept of, I mentioned prospect theory earlier. I want to leave you with some thoughts. Folks have heard of the concept of a BATNA, best alternative to a negotiated arrangement. That comes from Fisher and Urey, Getting the Yes, which is required reading for anybody who does this. But I have a concept that I think this is my own concept, and maybe I'll trademark this or something, of RECO, but it's RECO, and it's a realistic exposure to a catastrophic outcome. Um, Not only are you thinking about your best alternative, well, if we don't negotiate something, what's my best day in court? You hear that a lot. If we don't do a deal, what's the best I can get in court? And you'll hear people say, well, what you're getting today is as good as the best thing you can get in court. And if you can get the best deal in a negotiation or in a mediation, great, take it. But you should also be thinking about, what if everything goes wrong? What if I spend a bunch of money on legal fees? What if I deal with stress and I have my calendar eaten up for the next 2 years and I can't spend holidays and vacations with my family the way I want because I got to be ready to go to court and do other stuff. And I spend all this money, and at the end of the day, I lose. And I lose and I have to pay the other side's attorney's fees. Or at the end of the day, I lose and I got to pay a big bill. Or at the end of the day, I lose because I got a paper judgment that I can't collect on, or I didn't get the remedy that. What's your worst potential outcome? You have to balance those two. That's classic prospect theory. Daniel Kahneman, look that up. It's worth reading about, because that to me is the driver in most negotiations that come out of a lawsuit, and most mediations. It's prospect theory. It's what's your positive and what's your negative. And people are much more affected by the negative and a lack of certainty. And we see this in the stock market. Whenever there's a lack of certainty and a potential negative, it has a much greater effect than whatever the potential positive is.